Hello everyone, and thank you for joining us on this fourth episode of the Expert Review. Expert Review is a Harney's podcast series which hosts selected guests and friends who are experts in their field to discuss hot topics in governance, regulation, and tax, with a focus on issues that are the challenges faced by us as advisors, our clients, and the wider community. My name is Elina Mantrali. I am a senior associate at Harney's in our investment funds and regulatory team. We are joined again today by Phil Lee, partner in Fieldfisher's leading privacy, security, and information law group in London. I am delighted to have Phil join us, as he is a leading data privacy lawyer with experience on both sides of the Atlantic, having previously set up Fieldfisher's office in Silicon Valley. Today's episode will be a continuation of our topic from the previous episode on data protection. During that session, we had discussed various issues, such as the operational difficulties faced by undertakings both within and outside of the EU to meet requirements on international transfers under the EU GDPR, and more recently, by the Court of Justice of the European Union's decision in Schrems II. We also discussed the gap created between the requirements of the legislation and the reality faced by users of services requiring cross-border transfers to meaningfully review and assess the arrangements in place, taking into account the requirements imposed under the GDPR and also Schrems II. We had finally rounded off that episode with the recognition that, despite the challenges, these rules reflect a conscious decision to introduce this type of restriction, leading us to query the reasons for which there is such a push to regulate transfers of personal data so strictly in the first place. So, Phil, picking up from where we left off last time, taking into account these restrictions under the GDPR and also Schrems II, would you say that we are observing a push for protectionism over the cross-border custody and ownership of personal data? And I suppose, how do you see that interacting with what is, in practice, very much a global network of data flows?
I think it's very hard to shake the perception that there's some sort of protectionism going on in the EU. As to whether that's really what's driving a lot of this regulation, I don't know that is necessarily the case, or that it's necessarily the case in all quarters. I think the challenge that we have is that the data transfer requirements that have been imposed, particularly as a result of Schrems II, have turned the whole sort of analysis around data transfers into such an academic exercise that is almost impossible to satisfy completely in practice, that it's become very far removed from the reality of how data works. I mean, I think you just described it as being, some of this regulation as being slippery. I've often said to people in the past that trying to, protect all data all the time is a bit like trying to catch snowflakes as they fall from the sky. There's just a lot of it, and you can't grab it all with your hands. It doesn't mean you shouldn't try, but I think the danger is that if you make rules too tight, too difficult, ultimately what ends up happening is that you push organizations that otherwise intend, with the best of intentions, to achieve compliance. You just push them into a position where compliance becomes impossible, and then you create the perception that they are somehow, willfully non-compliant or ignoring the law, when really that just couldn't be further from the truth. I think the result of Schrems II is that we are moving away from the original intent of the GDPR, which was to regulate transfers of data and keep data safe, into something that is looking a lot closer to a data localization requirement, almost kind of compelling organizations to keep data in the EU simply because to transfer data to the standard that the regulators expect to see is just becoming a sort of an almost impossible task. Of course, we live in a very globally connected world, so I don't expect that to happen anytime soon. But what I do think will happen is that we will see more organizations transferring data accepting a level of risk around that, and inevitably some degree of regulatory hazard as certain companies get picked upon by regulators, essentially to be made an example of. And I think interestingly, this morning, I was actually giving a presentation to our team internally about the EU's new Data Act as well, which is a piece of legislation that's also going to regulate non-personal data. And within that, there are also rules around transfers of non-personal data too, almost kind of applying GDPR standards to non-personal data transfers. So you can sort of see that the kind of rules we've introduced to the GDPR that have then been bolted on with Schrems II are now creeping into non-personal data as well. So I think the reality is that data exports are going to become more difficult. And as that happens, the perception that the EU is trying to establish some sort of protectionism and just use it to promote its own industries is going to be a perception that will grow. I mean, with all these things happening, I'm interested to know from you whether other countries are still looking to the GDPR, particularly smaller jurisdictions, whether they're still looking to the GDPR as the kind of gold standard to achieve when they're developing their own privacy regulation. What do you think?
I really, really appreciate what you say about this point about the EU being perceived as trying to pull all the data in its own direction and within its own market, because I think when it comes to, let's say, encouraging the spread of GDPR, it's partly what the EU is using to enforce sort of such a spread is effectively its market, because it requires external service providers to get on top of its own rules. And therefore that is a form of enforced export of GDPR as the gold standard. So, there is a practical angle to calling it a gold standard when it comes to the markets that are most heavily reliant or at least exposed to European personal data in that respect. Now, in terms of a voluntary adoption of the GDPR as the gold standard, I think that does depend on where you look, because I think it's fair to say that GDPR is it is a product of Western regulation in that sense. But I think looking at that sort of sphere of influence, for example, the BVI and Cayman data protection legislation is closely inspired by GDPR. So there, I think, it is fair to say that there is an element of truth in terms of calling the GDPR a gold standard. Now, there are, I think, some challenges to that role. For example, specifically in the context of BVI and Cayman that I mentioned, the adoption of those rules were sort of in the run up to Brexit, that those discussions were parallel to Brexit. So I think it remains to be seen how this position will change if we see the UK diverging from the GDPR, given the relationship that BVI and Cayman has, for example, with the UK over the EU. And then another interesting development to look out for will, of course, be the US, because at present we see very fragmented regulation there. But obviously we've seen, California has come out with its own privacy rules. There is more and more discussion of privacy regulation in the US more generally. So I think going back to the marketing point that we made at the beginning, that whether you're the gold standard depends on what kind of clout you have to require others to take heed of what you're requiring. If the US comes out with its own more organized set of rules, that may well change the position of the GDPR. And the final point there is, of course, in terms of an emerging gold standard, if there is a version that is more competitive, as you say, I think we will see a preference for that as well, to the extent possible in terms of structuring operations. So there was something I wanted to touch upon in the context of Brexit. So we mentioned earlier that there is alignment currently, but what approach do you see the UK taking since Brexit in the context of international transfers and maybe GDPR more broadly? Do you see a commitment to maintaining sort of parity with the EU in this field, or are we observing any tendency to diverging from that?
I mean, it's a really interesting question. And I think when we talk about the GDPR applying in the UK, it's quite important for people to understand that we actually have essentially two GDPRs. We've got the EU GDPR, which applies in the EU countries. And now we have a separate UK GDPR. And basically what happened was that when Brexit occurred, the UK essentially cut and paste the EU GDPR into UK law with a few changes to make it work. for the EU. But broadly speaking, the UK GDPR and the EU GDPR are identical, as you've sort of alluded to. But the whole point of Brexit, whether you're for or against it, was for the UK to be able to carve its own path going forward. And so I think the inevitability is that the UK law will diverge from European Union law over time. The big question I think on everybody's mind is, how far it will diverge. Obviously, while we maintain very close consistency with the EU GDPR, the UK gets the benefit of being considered an adequate country, meaning that it is one of the whitelisted countries that data can be transferred safely to and from. The more we start to diverge from the EU GDPR over time, and we have in the UK published a national data strategy making various proposals about how we might remove some of the GDPR's red tape and simplify some things, and we may look to engage in more sort of open international data transfers than the EU does. The more we do those things, the more we put at risk our ability to maintain an adequacy finding from the EU. I think the big strategic decision for UK government to make is maintaining close parity with the EU GDPR. Is that worth the benefit of being considered adequate, or does diverging from the GDPR in a way that enables more flexibility and reduction in red tape, is that worth abandoning EU adequacy to achieve that? There's a lot of people who get very concerned about the UK losing adequacy. I think I'm slowly coming around to the view that removing some of the more difficult parts of the EU GDPR, the more sort of regulation for regulation's sake points, rather than things that actually provide substantive protection for data, removing some of those, even if it perhaps jeopardizes our EU adequacy finding, would be a positive path forward.
Yeah, so that basically brings us back full circle to the point about competitiveness on some level, doesn't it?
Absolutely.
Yeah. So I mean, I think it's so new that it remains to be seen how it all pan out. But at the end of the day, everyone will eventually try to find something that is easier. So I don't think that the practical challenges that GDPR presents will eventually be a hurdle to further development. Now, I think we are sort of short for time, so I just wanted to turn to something a little bit more fun before we close off. What are your thoughts and expectations in terms of privacy in the metaverse? And here I was thinking about something that perhaps we've already experienced in the context of, mass gaming, online gaming, for example, World of Warcraft, and how does that potentially compare to the new obsession with the metaverse in terms of privacy?
So it's funny. I think I'm one of those people who is sort of half excited by what technology can achieve and half terrified by what it can do. I think when it comes to the metaverse, I guess I've got maybe two or three thoughts. The first is that I think when people talk about the metaverse, they often tend to think of it in this kind of gaming context. But I think its applications are actually going to be much wider than that. I think what we are looking at is, the potential development of virtual reality, augmented reality, cross-reality applications and services that can function both in a gaming environment, but also in a business environment. Some of the applications I sort of see talked about, for example, are the idea that, you might be able to engage in, a video conference with people where you put on a virtual reality headset or some special glasses or something, and you see avatars of people sitting around you, so you can it's almost like you're engaging in person, even though it's all done over sort of like a video type call. I mean, stuff like that I think could be really fun. I think so. I think that at the moment people are talking about the metaverse in very conceptual terms, and I think there's still a lack of concrete proposals in terms of what the metaverse is actually going to do, what it's actually going to look like. So there's a lot of fun imagining what it might be. I think perhaps there's only a few people who really know how it's going to develop over time. I think the second thought, I guess, is that the metaverse, if we are talking about a world where we can interact in augmented reality and virtual reality, it's going to put pressure on privacy in the way that a lot of new technologies do. I mean, sort of a year, 2 years ago, everybody was talking about blockchain, and they were talking about some of the challenges around that, about the fact that, once data is entered into the ledger on the blockchain, it can never be removed. What does that mean for GDPR principles around processing data for no longer than is necessary? I think we'll see similar things with the metaverse, although perhaps even more extreme, because we will see issues around, people wearing or devices that enable them to see the world in augmented reality, but as they do so, they're capturing images or audio about people or places that they travel around. Those things are going to put pressures on privacy, and we're going to have to work out how to deal with those things. And then I think the third point, I guess, is that the metaverse either may be the next big thing or it may be the next big flop. And a lot of that, I think, is going to turn on the degree to which people have trust in the metaverse. And we're emerging from a sort of period of the internet where, the internet developed as something that was very exciting initially, and over time people have become a little bit more wary of it because of some of the online tracking or some of the content issues that arise on the internet. So I think the great thing with the metaverse is we have an opportunity to start again and say, okay, we're going to launch this thing. How do we do this right? How do we overcome some of the problems that we've experienced with the internet and build for a metaverse that doesn't do that? And I think if we can get that right, then I think the metaverse can be turned into something really fun and really safe and something that will attract a lot of attention. But if we get it wrong, absolutely the opposite will be true. So I'm cautiously optimistic and hopeful, but we have to wait and see.
Well, I hope it will be the positive version, but we shall see. So thank you very much for that. I believe that brings this episode to an end. And to all our listeners, if you're interested in further information, we cover data privacy and other interesting topics on the Harney's regulatory blog. You can also visit Fieldfisher's Privacy, Security and Information Law blog, which focuses, as its name suggests, on all matters privacy, security and information law. Thank you again for joining us today, and we hope to see you on our next episode.